I define cross-border mediation. It's like plugs and phone sockets. You need to have an adapter because otherwise you are not going to get any electricity.
Mediation. Mediation is often imagined as a neutral space, a calm room, two parties, a skilled facilitator, a process designed to reduce conflict. But the word mediation wobbles long before anyone crosses a border. Even within the same country, it can point to very different practices, different roles, different levels of formality, different ideas of what a mediator is allowed to do. And once you add borders, the wobble becomes impossible to ignore. Because before the dispute is negotiated, the process itself is already contested. Who speaks first? Who has authority? What fairness looks like? What resolution even means? Welcome to Insubstantia. I'm Gabor. My guest today is Manon Schonewille. This conversation moves across jurisdictions, professions, and philosophies of mediation. We talk about how culture shapes expectations, why misunderstandings often start at the level of process, and what it takes to build a workable frame when the parties do not share the same assumptions. If we cannot agree on what mediation is, what exactly are we doing when we say we are mediating? That question sits underneath everything that follows.
To start off, I think it would be best if you begin by introducing yourself so the listeners get to know you.
Okay. Well, thank you, Gabor. It's a big pleasure being here today with you and speaking about this fascinating topic of cross-border mediation and intercultural aspects. I am Manon Schonewille. I am actually active in mediation since 1995 already. So it's a long time hobby and work. It's a niche in a way, but I do a lot of different things in mediation. So I train and teach others who would like to become mediators. I am a mediator, obviously, doing cross-border, doing business-to-business and employment cases. And I write books about mediation and negotiation techniques. So that is the most important background. If you want to read more, by the way, I have my own website. It is manonschonewille.nl, and it's in English, so most people will be able to read it.
Great. So what are the latest publications that have come out?
Yeah, actually, last year and this year, there were some publications. Let me show them to you. So there is the book Toolkit Mediation. This is the English one, and this is the Dutch one. And it is a book which has a lot of checklists and overviews on how to do mediation and what to do during the process. It's helpful for mediators who are, learning how to mediate, but it's especially useful for in practice. A good friend of ours, I think you also know him, Jeremy Luck. He says, I always bring it to my mediation because if you get stuck somewhere, there's some kind of checklist that you can use. And the other book is about mediation advocacy. It's now in Dutch, but we are currently translating it to English. What's also nice and I think relevant for the discussion we have today is that this book, the Toolkit Mediation, is currently being translated in the Korean language. And so when you do that, of course, it's not just like, literally translating what is said there, but some of the practices are different there. And I'm very fortunate that a colleague who is very experienced in mediation is the one who said, I would like to translate it, but also add some of the things that it makes sense here in Korea.
Yes, we'll get to the different ways of practicing mediation around the world when we talk about your previous book, Variegated Landscape of Mediation, which covers the practices of mediation in about 50 countries or so.
Yeah, we say it's about 50 countries, but we say in around 60 different jurisdictions because we have several states of the United States, for example.
Okay, so we'll get into that afterwards. First, I'd like to learn more about you and your practice. How would you describe your personal philosophy and approach to mediation?
I think it evolved over the years. When I started, I was first trained to be a very facilitative mediator and in a pretty strict process. So this is the step, and then you need to do this, and then you need to do that. You're not allowed to do these things. And I think over the years, I've become much more flexible because there is a time and a place for everything in my experience. And there are even situations where it's better to move to a different type of process where you go out of any rules of mediation because that is what the parties need. So I would describe it as flexible and adaptive to now where's the border, the flexibility and adaptability to where it feels right for me, that it fits with me and my style, that I know I can serve the parties at the best possible way. But also that it is useful for the process and fitting to the parties. So that are in fact the markers that I use. If you ask me about my default way of mediating, I am pretty directive on the process because I don't want that to become another issue between the parties. So I'm the expert on the process matters, and I can bring that in. However, if the parties are well known with mediation or have very particular wishes that both of them are aligned to, of course, I'm open to do that. But in general, this is also what the parties like and expect me to do. And then on the process, so that's the process. For the substantive aspects, I am more facilitative and solution focused, unless at the end of a mediation, parties would like me to be more active. So that is the default setting if you ask for that.
Okay, we'll get into how your practice has evolved, but I'm intrigued by the word directive. What do you mean by that?
Yes. Well, as a mediator, you have actually two axes or choices how you shape how a mediation is being done. And the one axe is how do you deal with the process? Are you what I call directive? Are you the one that is actually deciding how the process is being done? Or are you facilitative in that aspect? And do you leave also that part of the mediation with the parties? So you either have a discussion about that or you just ask, how would you like it to be? Or if you go a little bit backwards toward a little bit more directive, you give some choices like, would you like to have some pre-mediation papers to be exchanged? Would you like to be in joint sessions only or caucus only? Or would you like to have a mix? Who needs to be at the table, etc. Towards the other side, where you're more directive, that you say, okay, how I'm used to do the mediation is that I will start with individual meeting with each of you. It's like an intake for the mediation process, after which we can better decide how the mediation is going to take place. And I would not like to have these stacks of papers, but if you feel like sharing something, in any case, let the other party know you do it. But please, like 5 pages, what is the main thing? Something like that. And so that's the difference between being directive and facilitative. And I tend more to be directive.
Looking back over your career, which moments or cases have most shaped how you mediate today?
Yeah, there are many cases. And actually, that's the beauty of mediating. Each case you learn something, and every time there are things that shape your way of mediating. But some fun or not so fun, but good learning moments were actually by my first mediation. After being trained here in Europe, I went to the United States to be trained there. And part of that training was that you could also do actual practice mediation, which was really nice to gain experience. So it was a big mediation center. They had many cases. The first case I had, and it were, relatively simple cases in the sense from the substantive aspect. However, they can be very complex because often they are single issues. And the more issues you have, the easier it is to find the solution. So this year it was a seller from furniture and a lady who purchased a recliner, and the recliner had to be repaired like 3 times already, and she was fed up with it. She said, I want you to take the recliner back, and the seller said no, because the guarantee has already been taken off, and by the way, looking at you, she was quite big. You just, if you put like that in the chair, then of course it will break, and that is not quality of the chair. So that was the discussion that we had. And it kept on going like that. And I thought, oh, why me? Why now? Why this as a first mediation? And then the lady mentioned, yeah, and besides all of that, there was also the issue with the dogs. And, and actually only because I panicked and didn't know what to do anymore at my first mediation. I asked, can you tell me more about the dog? And she says, no, it's totally not relevant. I said, well, but please tell a little bit more. Well, what was with the dog? And she said, well, we are, my husband and I are both working. So we give very, very specific instructions to close the fence very, very tight because of our dogs. And then when the recliner was delivered, they forgot to do that, kept the fence open. When we came home, both dogs were gone. We were super worried. One of them we couldn't find for 2 days. Then that dog was at the dog catcher. We had to pay like $125 to get him back, and it was really, really bad. And then the seller, who he was a Texan, young, including big hat and boots and stuff like that. And he said, oh, ma'am, I'm so super sorry to hear this. That is unheard of. I will speak with my boss, and obviously we are going to reimburse the $125. And so I said, oh, that's really interesting, because that was a blocking or underlying issue. And then she suddenly goes like, yeah, and if you do that, okay, you can repair it once more, and we're good. I was like, okay, we're settled. So for me, that was really a defining moment. Like, okay, listen for the side sentences, ask things where you think that had nothing to do with the substantive matter. That is where the gold lies in mediation. So it was actually a very good first mediation. Yeah, some other. I mean, I don't know how many examples you would like to have.
No, it's fine. This example perfectly illustrates the fact that the issue that we are being told is the issue is not really the issue. So that's how we train as mediators. Explore. Exactly. You have to dig, because what they see is the issue is not really the issue.
Exactly. And yeah, another mediation, actually, that was that you really need to refrain from, having a, how do you say it, being judgmental or whatever, even in your head, even towards the parties. I remember a mediation I did where it was between 3 young entrepreneurs and a lady who was an interim manager. So she was only there for a certain time in order to get some projects being done with a large organization. And she had started to work there like 2 months before the mediation was there, and she wasn't involved at all in the issues, it seemed. And so I had asked her a couple of times, like, okay, how was the start? And because she was really, really fed up with the 3 of them. She was very angry, and in my eyes, very erratic. So like 2 or 3 times during the mediation, she would get up and say, I'm out of here, and asking her lawyer to leave with her. But then the lawyer would remain seated, and then she would come back, and being very, very hostile towards the 3 entrepreneurs. And I just didn't get it. So this was one of my longer lasting mediations. It lasted over a year, 1.5 years. And then more towards the end, when she already said, I'm not going to sit at the mediation table anymore. So we were just negotiating with, on her side, the lawyer and some of her colleagues. I had a caucus meeting with 3 entrepreneurs, and I was already at the door, and they told me, well, you asked several times, is there something you would have done differently if you could start over again. And yeah, maybe in hindsight, it was not a very good idea to personally summon this lady and give an indictment when she had just started working with the company. Oh my gosh, that of course she is angry. She starts working with an organization that has this person standing at her door, with summons. So for me, that was a great learning. In the end, this case settled. She tried to stop it from settling. However, the entire team around her and everybody wanted to settle. So, whenever we came with a settlement agreement, she would find fault in it and we would negotiate as long as that was gone. So in the end, she couldn't say no to anything anymore because we had a deal. But she was very unhappy with the mediation result. And I can imagine that. So for me, it was a really, really good learning. I mean, the good thing for the companies was it was settled. But yeah, listen to the sides, and if things are really uncommon, or you think that this is erratic behavior, or things are strange, keep on asking. Don't just say okay with the first answer you get.
It's interesting. I thought we would talk about this a little bit later. My approach is I don't have the same experience as you do, not in years. But I think that's what I have gotten out of my training and of the experience that I've acquired is that there's a very important aspect to focus on initially. And when you are able to get over that, things will kind of work themselves out much easier. So
Exactly.
I focus initially on the relationship and on transforming it. So if you realize that there is a tension and you can work on that tension, once you are able to establish what the tension is, why people feel tense and bad and upset at one another, and you can get them to recognize that there has been an issue, then have a common beginning of the story where things started from, and then apologize or acknowledge or something, then the tension drops. And a few words of apologies will suffice to get back
Mm,
to a collaborative state. So this is my main focus.
yes.
I suppose in some cases it's very difficult, and I realize that in some family mediation
Mm,
it's not possible, or you have to approach it very cautiously or from a very different angle.
yeah.
But if you get there, then you're not really important any longer, because they are in speaking terms again. They become reasonable again.
Exactly. Yeah, I totally agree. So you first need to have a relational or relationship settlement. And what I always do in the mediation is look for the blocking issue. What happened that these persons did not find a resolution among themselves? And what is standing in the way. And once you find that, and sometimes, like in the example I gave, you find it very, very late on, then you can find a settlement. However, not all parties are ready and willing to do this work and to speak about it. And so, in the example I just gave, I asked a lot of questions about it. However, the lady just said, "No, this is just work. It's about money. I just started working here in order to clear up cases like this. So that's it. And who am I to say, I would like to, really go in depth all of the time. So it's always, a balance between how you think the mediation should be done and what you know which tools work, and when the parties are ready to follow your flow in that. And the other thing you were saying, I also totally agree with that. You say it's not about you. You can go out of the equation, and I think that is one of the main things you need to do in the mediation. If you want to shine and show off, look, I helped you find this solution, and I was so important. You are standing in the way. So you need to make the parties feel very comfortable and good about themselves. And, look, we found this solution. We have been able to do this. Whereas at the background, you have been setting the scene, helping them to do it, in a way, even manipulating them. I mean, I know the word triggers a lot of mediators, but even by just being there, listening to the party, looking for the blocking issues, you are already manipulating. So maybe we should find a different word, but influencing maybe, or impacting is probably the better word. That is what you do, but you don't want to, or you shouldn't, don't want to be recognized for that as a mediator, because then you will stand in the way. Then it's about you. It's not about you.
Yes, you have to remain on the nudging side. Just nudge a little,
I
and
like nudge. Yeah,
don't go beyond.
exactly. Exactly. Yeah.
How do you balance your roles as practitioner, educator, and author? Do these roles reinforce each other, or they sometimes create tensions?
I think mainly it's a very strong reinforcement. I learned from each training, I learned from each conversation, all questions that my students ask. There's always somebody who comes up with a new topic or a new dilemma, so I learned tremendously from them. But also watching the role plays, for example, where somebody really uses a nice technique in order to get things moving, and so I enjoy that greatly. And then I take that back to my practice, and then I teach it others again. Like, okay, these are the experience that I have. So the only time where it would create tension is in time. Where do you put your focus? But it's not that I am in more academic mindset when I'm mediating, for example, because I do research. And I think having the practical background does help when you write books, and so that's not just from theory.
We'll turn to the book through which I got to hear your name for the first time. I think it was Jeremy Lack who mentioned that book. It's the variegated. It's a complicated word to pronounce. Variegated landscape. I actually didn't know that word before I knew about the book. So the variegated landscape of mediation, and I thought it was a fascinating undertaking to look and compare all the different ways mediation is practiced in 50 countries and about 60 jurisdictions. So what sparked the idea to undertake such a large comparative project?
Incredible naivete, and not realizing what a massive project it would be. So at that time, I was working on a lot of international projects. So I did mediation projects for the European Commission, for example, in Turkey. We did work in Greece. I was traveling around and doing a lot of trainings in several countries. And then noticed that, well, first of all, in particular in Europe, we were busy making mediation legislation, and there were many different rules and approaches to that. And I thought, you know what, I'd like to have an Excel sheet where I just define the most important things that mediation are, like, okay, it is confidential, who can be mediator, do we already have legislation? So a couple of simple questions, and I will ask a couple of colleagues just to fill it in with a yes or no. And then when I got back the first answers, I realized it is much more complex, because in many countries, you cannot just say yes or no, or to questions where you say, like, for example, is mediation being initiated more from the government side, or is it more initiated from the private side? So in some countries, the idea was, okay, the private side as mediators among themselves organize themselves and set up the rules. In other countries, it was, no, it is how the parties are doing it. So already a simple question like that, you had cultural influences and things were interpreted differently. Plus, I had some really mind-blowing answers. So for example, I thought, okay, I will have a list of, in each and every country around the world, these things are mediation. I wanted to have a list like that. I thought that would be easy. And one of the things on top, it is confidential, unless the parties don't want to do that. And then I saw that in Finland, there is something called in-court mediation, where a judge can become a mediator. And then, of course, it's per definition not confidential because, it's being done at court. Of course, I think they will make it confidential in the sense that they will find the place. But in theory, so that really blew my mind. And also hearing about other practices. And so I wanted to expand that, and then started to collaborate with others on that. And then suddenly you have an 800 pages book. So, yeah.
Yes, I did have also a naive undertaking when I finished my training, because I realized that it was difficult to come up with a unique definition of the word mediation. And so I even wrote an article saying that if we have to mediate about defining what the mediation process will be when we do international mediation, then it's not constructive. Can't we come up with one word and then call the other processes something else? And I remember looking, for instance, at how the word mediation was used in the UNCTAD document, which was a very important document for commercial mediation, international commercial mediation. And at the onset of the document, they wrote that they were using the word mediation and conciliation. For them, it meant the same thing. So I just searched. I did a search in the entire document and realized that maybe the word conciliation was used 250 times and the word mediation maybe 50 times. But in Switzerland, for instance, conciliation is a process that's part of all civil proceedings.
Yes.
You begin with conciliation. That is led by a judge, and it takes about 30 minutes or 25 minutes. And it's very different from mediation. What I liked about mediation, or what I took away from my training, is that the mediation process is informal.
Mm-hmm.
The informality I thought was very important because you're not committing to anything. And when you come out of it, well, you come out of it only because when there is an agreement is because everybody agrees. You're not forced into that. And I tried to set up something where we would establish rules under which we could do international commercial mediation and define what we mean when we say mediation. It didn't work. I gave up very quickly.
I know exactly what you're talking about because I had some moments like that during the variegated landscape. It's now that I more than 10 years further on, I'm not sure that we should have the need to define what mediation is around the entire world, because if you there are so many different practices meanwhile, that I think it's not possible anymore to do that. But there are some pretty cool new ideas and tools how to get around it. I think we will get later on in the interview on that. And yeah, one of the challenges we have here in Europe with what mediation is and the definition of mediation is that in the European directive, mediation is not really well defined. It's very fuzzy type of, it says it is a structured process, however named or referred to, whereby two or more parties, do certain things, and it has to be voluntary. Well, big question mark from my side, because judges can refer to mediation. How voluntary is that? So really, really difficult. And then you could hope that, okay, it's led by a mediator. Maybe mediator then is well defined, but that's also not defined in there. It's any third person who was asked to conduct a mediation in an effective and impartial and competent way. So many different processes, including the conciliation that plays such a big role in Switzerland, could fall more or less under that definition, unless you say, well, it's not voluntary, so it doesn't fall under it. But and I think that is why mediation is now so complex, in particularly in the EU, to predict what to expect in a different country if you go across borders, because it was left totally open. It was only for cross-border cases. So, the jurists who started working on it, or the legislators, who in some countries, it was just developing, that not a lot of experience with mediation yet. And so they started to implement their legislative thinking and ways on mediation. So we have wildly differing regulations within Europe in particular.
Yes, I was surprised to learn, for one, that administrative mediation in France is done by the judge, who after the proceedings makes a decision. So it's not a very neutral process. And yeah. So how did you identify and approach the contributors for each of the 60 jurisdictions you covered?
Yes, well, because I was active already internationally, I knew a lot of colleagues from several countries, and many of them had already written books or were at least very active. So I approached them first. Would you like to write a chapter not just on your country, because you will write it from your own understanding of mediation, but in a structured way, like saying yes or no. Okay, as a compromise, you can put yes or no between brackets. So, that gives a little flexibility, but so that we have a direct comparison. And most of them said yes. And then I also asked them, okay, what other countries should we include? And do you know somebody in that country that you can put me into contact with, and which you can really recommend as the go-to person who knows about these things? And that's how it came. And even in let's say the last month, where we were gathering things, new countries and new colleagues came in.
So you already mentioned that there were some surprises when collecting and comparing data across so many legal and cultural contexts. What were some of the most striking insights you personally took away from the preparation and research process?
Yeah, but lots of them came up. So actually, how after the variegated landscape, I define cross-border mediation. It's like plugs and phone sockets. You need to have an adapter because otherwise you are not going to get any electricity. So, for example, one thing from a Dutch perspective, which I find very interesting, is in my country we say, okay, lawyers are or other supporting parties are allowed to be present during the mediation if the parties and or the mediator wish so. However, there are countries like, for example, Greece and Italy, where legal representation in mediation is compulsory. And so it's not just like, okay, they are allowed to be there. No, if you have a formal mediation, lawyers should be there. So that was for me a very interesting thing. Also, if you don't perform the mediation up to standards, your obligations and liabilities as a mediator, from my understanding, always was it's a civil law profession. But in Austria, if you are a registered mediator and if you breach confidentiality and violate with that the interest of another person, you can be prosecuted under criminal law. And one of the punishments could be imprisonment for up to 6 months, or you can get a fine. Luckily, I don't know of any cases where that happened, but for me, that first was like, really, I don't get it. On the other hand, if you look at other professions where you have professional liabilities, like being a doctor, or that could also be prosecuted in many countries. So it can also be seen as a sign that mediation is being, grown up or being taken very seriously. However, for me, that was one of the things that I said I find it, hard to comprehend. Just like in many countries, including Switzerland and the Netherlands, fees are freely contracted between the parties and the mediator. However, in some countries, there are minimum or maximum rates per hour or per date or per mediation, or a maximum number of hours that can be charged. And so there are many, big surprises that that came up.
That is the case now in Geneva. You know that Geneva has introduced a mediation office that will cover the fees of a mediation when they're connected to the canton of Geneva. It's only the canton of Geneva that does that. As far as I know, I don't think that other cantons have introduced that for the moment. So you have a set amount you can charge per hour. And there's a maximum number of hours that the mediation can run for. It's 7 repeated 3 times. So the mediation can run up to 21 hours.
Okay.
I suppose that if it has to run longer, you can maybe ask for an extension. I am not aware of cases that have been extended so far.
Okay, interesting. And but that's only for court-connected cases, or is it for
No, anything.
All mediation? Wow.
Yes. If you have any issue with anybody, you can ask the mediation office or say that you would like to mediate the issue. It doesn't have to be a legal, civil or penal case. And then the mediation office will consider the issue, and usually they will say yes if it's connected to, so if it's a neighborhood dispute or if it's a commercial dispute or anything, you can get in touch with them, and they will give you a list of 3 mediators who are qualified, who are sworn mediators, and then you get in touch with them, and if they accept the case, then it will proceed. Obviously, both parties have to accept. That is absolutely indispensable. It remains a voluntary process.
Interesting. And does that only count for cases that go through this mediation institution office, or is it for all? Even if parties would say, okay, Gabor, we would like you to be our mediator, are you then still bound to these rules, or is it only if parties go through this mediation?
No, you're not bound to these rules if you're not going through the office. But then they have to pay me. They have to pay for the mediation. If they go through the office, I'm paid by the office.
Why would they do that if they have the
exactly?
Other? Okay, I get it.
But then the only caveat is that you are limited in the number of hours you can bill for preparation. So let's say it takes 20 hours or 10 hours to set up the mediation because you have to make repeated calls and convince both parties. You cannot charge those 10 hours. They're not billable. You can charge 30 minutes. That's it.
Oh, seriously?
Yes.
In my experience, most mediations take up longer than 13 minutes to get everybody ready, prepared, in the right mindset at the table. And what about intake meetings then? So the way I work, like I just explained, I start the mediation process with individual meeting with each party to discuss the process and to discuss what their objective is, etc. Would that fall under the 21 hours or the 30 minutes?
No, so this is more technical. I think if the mediation has been accepted by both parties, they've committed to do the mediation, then they fall within it's the preparatory meetings. They count as mediation hours.
Okay, but they don't always accept to do mediation before this intake meeting. For me, it's a nice tool to influence them to start doing mediation. Just say, okay, why don't we just have this 1 or 1.5 hour meeting, and after that you can decide whether you want to start the mediation process. So
that is the caveat. So
okay.
It's complicated to organize. has. And yes, so well, there are some issues, and probably with time things will evolve because it's only 2 years old.
Okay. But interesting that measures are being done at least to stimulate mediation. That is great.
Yes, it is. Although, when they first introduced it, I was under the impression that, or I was wondering whether it would be beneficial or detrimental, because to some extent, it's like going to a psychiatrist. You pay, and the fact that you're paying means that you're engaged with the process.
True.
And since you're not paying, someone's paying for you. The question is, how engaged will you be in the process and its outcome? So I don't have an answer for that, but those are things that were running through my mind when it was introduced. So let's look at it from a positive perspective and say, yes, it's enticing for people to consider mediation first and to find ways to get out of their conflict. Now, the psychological aspect is secondary for the moment. Since publishing the book, what lessons or shifts have you integrated into your practice? Could you share examples?
Yeah. The most important one, always mediate the process first, and particularly in cross-border situations. So that's the most important one. And everything else falls under that. So don't assume the parties understand the process, understand mediation, know what we expect, let alone that it's aligned with both of them. So that was my most important takeaway from it. Yeah, and for the rest, the takeaway is that if something doesn't feel entirely aligned or right, or you keep on hitting some walls or little resistance, discuss that. It can have a reason, a very neutral reason actually, that everybody has different understandings of the process. So make the process an important part of the mediation, and not just do things.
The book points out, and we already talked about it, that countries use the same word, mediation, that often mean very different things. Are there striking examples of contrast between countries that we haven't discussed yet that you'd like to share?
Well, actually, that's the core of the book. Because we spoke about the process and the different approaches mediators can have, from directive to facilitative on the process. But there's another X, and that is the X of the substance. How do you deal with substance as a mediator? And in many mainland European countries, as a mediator, you're not supposed to be very actively involved with the substance. However, in many Anglo-Saxon countries, for example, it's the expectation that you are more proactive also in this respect. And interestingly, I just conducted a much more recent research here in the Netherlands together with a couple of colleagues. And we did it 5 years ago, and then now we checked again. We spoke with lawyers and with parties who had actual mediation experiences, and asked them about, what do you expect from the mediator? What role would you like the mediator to take? Here in the Netherlands, originally, it is very, very facilitative, both on the process, but in particularly on the substance. And more than 80% of the parties said, we want a proactive mediator who is doing heavy reality testing. Around 80% of the parties even wanted a mediator who, if they don't reach a solution, gives a binding advice, how to, which, well, in most people's definition, will fall outside of mediation. You can mediate proposals, but it shouldn't be binding. So, yeah, those things, we are still in a process of developing and learning what mediation is and how to best, perform it, implement it. And for me, having this awareness of there are different styles, and you don't need to just be accepting what the mediator is doing. You can play an active role in that as party, and think beforehand what type of mediator and what type of process would you like to have is very beneficial, because differences between Anglo-Saxon countries and European countries, and particularly German-speaking countries, for example, where it's very facilitative. Or if you would go to Asia, where it's more like a social process where it's really important to keep face saving, to not look at it from an individual point only, but also have a more, what does this mean for the collective, etc. It's wildly different. And just throw one mediator inside there would just come, but this is how I do my mediation bank, and that's how we're doing it. At least one of the parties is going to be super unhappy. And the problem in particularly arises if one of the parties' expectation of the mediation matches how you do the mediation much more than the other one. If there's a disconnect on one side, you're not neutral as a mediator, whether you know it or not.
Yes, that is an interesting way to look at it. What you were saying about what the polls were showing about what people prefer matches some things I've read about why people would choose arbitration over mediation, even if you tell them that the arbitration process will take 1 year or 2 years, will cost 50,000 euros, whether the mediation process might only cost 10,000 euros and can get you to a solution within a month or two or less. And the reason is that it's the uncertainty. So out of the arbitration process, they're willing to pay to get something that is clear. It's hoping they'll be vindicated with their claim. With the uncertainty of the mediation process, you only come out vindicated if you consider the fact that you have transformed the relationship and been able to decide together what's the best for the both of you. And it's difficult to wrap your head around the idea that some people are only entering the process and would prefer to have a mediator that becomes an arbitrator at the end, just so they can hope to be vindicated, proven right, and not consider how to best resolve the issue in a way that's really win-win for both.
Yeah. It's in fact, in all the research also it is much easier to sell a result, even if it's worse than a mediated outcome, to your constituency if somebody took a binding decision. And I think we as mediators should be more open and start taking these things in. I mean, you don't need to do that as mediator, but you can create a hybrid process. So you can bring in the decision maker. You can bring in somebody who gives a legal assessment or a financial overview where you say, okay, let's accept this to be true. And if you settle, it becomes binding, those kind of things there. And I think that is where some of our future developments will be. But we'll come to that later.
Yes, we'll come to that later. I have some issues with this kind of approach for mostly philosophical reasons.
And that is what happens all of the time. This is mediation, that is not mediation. Whereas in the course of the year, I used to think like that, because mediation should be a clear process and you should know what you get. And we know that certain things work, and that's why we do that as mediator. On the other hand, if you look at it from maybe a bit more pragmatic stance, here are some people or companies who have a dispute and they want it to be solved. That's more how I am thinking right now. What is necessary in order to help them to get out of the misery place they are in now? And sometimes I do things that are not mediation, and it helps them to settle, and they're happy. So
yes, well, we'll offset that, because sometimes on the short terms it's beneficiary, but if you consider that from a longer term perspective, it might be counterintuitive. Many civil law countries sharply distinguish, we've seen, mediation from conciliation, while others blend or confuse the terms. Why does this matter in practice, and how does it affect ethical standards like party autonomy and informed consent?
The interesting thing is that the discussions about conciliation versus mediation, I only have with Swiss colleagues.
Okay.
So Jeremy, for example, very often comes up with conciliation. I mean, in other countries, including the Netherlands, there are types of conciliation. The judge tries to get conciliation between the parties, but it's very much distinguished from mediation. And, as long as you know in which process you are operating, then it's fine. I think you can combine it, but you should not do things like on an automatic pilot. So don't mix these two things, but let the parties know where you are. So, for example, what I just said, you start with the pure form of mediation, working on the relationship, looking at the underlying issues, looking at the blocking issues, etc. And then maybe you can shift towards the end, towards saying, okay, maybe it makes sense for me to help you thinking more actively. Would you like that? And then you can go towards conciliation. So as long as it is clear what you are doing and the parties understand what process they are engaging in, I don't see any ethical issues, but it needs to be clear. So the problem starts if you just start doing something and it's not clear where you are.
Can you share examples where one country sees as good or fair mediation practice would, in another cultural context, be seen as ethically questionable or even unacceptable?
Oh, yeah. However, it's not always just about the country. It can also depend on the parties. But if you look at some, and I am grossly generalizing here. I know in every country there are mediators that do it differently, etc. But just looking at with my Dutch glasses on, how I look at certain countries. So, if you go to the US or in the UK, mediators are much more driven and focusing on the substance and can do some really, really heavy reality testing. Or even I heard from some colleagues who said, well, we work with repeat players like insurance companies. And then I will sometimes just go in and say, hey, John, I need you to really give in $100,000 now. I will get it back for you in the next case. I don't say all Americans work like that, okay? But I heard it from an American colleague who works like that. If that would be done in a country like Germany, for example, when I show them the demonstration videos that we just produced on how to work directively on the process and evaluative and facilitative, or how to work evaluative and facilitative on the substance, even asking some things like, okay, what if this would be accurate from a legal point of view? You're not allowed to do that as a mediator. So I think that would be seen in many European countries as an ethical behavior. For me, I think there is also the border of what I find okay and still mediation and not. If you start mixing cases because there is the same party, that's not mediation anymore, because you take away the party autonomy. And so there would be a limit for what I find acceptable as well. Being super evaluative, which can be viewed also in a different way, maybe in Asian countries and in many European countries. I think sometimes it's necessary. Sometimes you need to knock some sense in the head of a party. They have totally unrealistic ideas, or they have put themselves in a position where they really cannot back off, for example, towards their constituency, and you need to help them. Because if they go to court, it will be very, very bad for them. On the other hand, they will have a paper. Look, the judge had a bad day, and my lawyer didn't perform well, and this is what happened. And that's that's a sad thing, but okay. In the end, you need to accept the party autonomy.
It's interesting because the United States is a very interesting case to study. I mean, there's so many different ways to consider mediation. On one hand, you have humanistic mediation. That is where the mediation emerged from, and the new wave of mediators came from in the late 80s, early 90s. And Ken Cloak is one of the main figures of those mediators. And on the other hand, you have the business mediators, where the mediator is hired by your lawyers. He never meets with the clients, only with the lawyers. And they use the mediation, or the so-called mediation process, as an exploratory process to know what the other side's position will be in case they go to court. So there are widely different ways of approaching mediation. And ethically calling that mediation is questionable as far as I'm concerned. So are the different mediation styles, such as facilitative, evaluative, directive, or transformative, sometimes in tension when applied cross-culturally?
Yes, of course, there's a lot of tension, and especially if the mediator also brings in his or her own cultural perception of what mediation is and what not. So if you look, for example, I did a few cases with Korean parties, and I'm by no means an expert, even although my book is being translated in Korea, where avoiding face saving is, for example, really, really important, and also looking at things more holistically. So what does it mean for the whole of the company, or maybe even the society? Versus, for example, a Dutch person who is much more individualistic and who, just speaks out their mind. And I had a Korean CEO with a Dutch manager and couldn't collaborate together very well. And there was at some point an incident where the Korean CEO said, well, when we went to Korea, you insulted me so much. It was incredible, the words that you said. And then I thought, okay, what to do now? Because if I'm going to ask the Dutch party, do you remember the incident? And please repeat what you said so we can speak about it. There's another insult going over the table. So I decided to do that in caucus. And being Dutch myself, I was really happy that I did that, because the Dutch manager said, I don't really recollect. I said, yeah, at some point I told him something was bullshit. And, in my mind, I had thought about some much worse words being used. But that was already, you don't contradict your boss in no way. That is already a big insult. And so in that mediation, we looked at, okay, can we at least between the two of them find an agreement on how it would work for the whole, on how they would communicate when others are there or within the Dutch branch of the organization, and what do you think is face saving or losing face, and those kinds of things. So that is where it can play a role. And another thing is, if you have countries that have a high uncertainty avoidance, as a mediator, it would be wise to be more directive on the process. Because if you then start saying, well, how would you like me to conduct the mediation? This party doesn't feel comfortable. And the biggest challenge is that you always have two parties at the table. So maybe the other one feels super comfortable and feels super uncomfortable with when you say, this is how I conduct the mediation. And that's why I'm saying it once again, mediate the process first. That's the most important thing you need to do.
To fall back on the proposal that I tried to work when I completed my mediation training, I suggested, inspired by the work law protocol, where that was established by German and Polish mediators on how to manage a cross-border mediation involving complicated family tensions and matters.
Child abduction and things like that? It's that type
Yes,
of...
abduction. So they always have a male and a female mediator, and they both represent the two cultures involved. And
Yes.
that was my proposal, that all cross-border mediation involving whatever, all cross-border mediation should always be run by co-mediators, both representing the two parties. They don't necessarily have to be men, women, although I find that co-mediating with a woman brings a very interesting dynamic to the mediation. And if you can introduce the fact that there are two different ways of considering for cultural reasons, that facilitates also the dialogue. Because for one, the mediators are showing that they can cooperate.
Exactly.
And the other is that because one can maybe be the plug, the translation plug you were talking about, for the other, and that makes the connection easier. You can explain to something that was received as an insult that it wasn't meant as an insult. It's
typical Dutch behavior.
Yes, but if the mediator is only representative of one side of that, it doesn't create the dynamic that you want to establish. There is this trust issue. To what extent can I open up and share whatever I have to share?
Yeah, thank you for bringing this up, because I hesitated a lot before taking on that case, exactly for the reasons that you are saying. But they couldn't find a mediator that understood Korea here in the Netherlands. It was very time intense. They needed somebody fast. And it was not about a lot of money. They didn't want to spend, money bringing somebody from Korea over, for example. So, but this, once again, mediated process first. You need to discuss this with the parties, which I did, and in particularly with the Korean party, saying, "Look, I really only know very little about the Korean culture, and it may be that unknowingly, I can do things that offend you or that don't feel right. And how are we going to deal with that?" And actually, this party did correct me once during that mediation, when you have the flip overs, and there are always the the black and the blue pencils are always not working anymore. So there was the red pencil, and I started to write some things. And he said, "That's a big insult in Korea. Don't use the red pen, okay?" So, and I was happy that he told that. But going back to your question about co-mediation with mediators with different backgrounds, I think co-mediation worked excellent in cross-border cases for all the reasons you are mentioning. I would be very hesitant, though, to put up rules like it has to be like that, or it always has to be a male and a female mediator, or like what they're doing in Austria with family cases. It should be possibly male, female, and somebody with more psychological and somebody with more legal background. Because it depends on the case, it depends on the parties, it depends on the circumstances. So always investigate whether it is possible and makes sense. However, don't make it compulsory.
Well, I'm part of an intercultural mediation group here in Geneva, and it's a rule. We don't engage in mediation alone. We always do co-mediation, and we always do co-mediation taking into account the cultural elements present in the mediation. So sometimes it's complicated, and we have to go and look for someone who has a command of a language that we don't cover. But it's an interesting challenge.
Yeah. And do parties always want to pay for both mediators, also in cases that don't have a lot of financial value or smaller interest?
Well, it's as a rule, we offer our services as co-mediation, but we don't overcharge. It's like we split the difference. It's an ethical approach, and we accept to work for less in order to be able to offer that ethical approach.
Yeah, very nice. Beautiful initiative.
So we've covered many things, including some of the things that you said about the European Mediation Directive. And just wanted to fall back on that. To what extent has it helped to create clarity, or has it introduced more confusion by mixing variants of mediation and conciliation under one legal roof?
Yeah, well, actually, I think it totally missed its objective, which was to have a predictable framework if you go across borders with mediating in Europe. For the reasons I just said, most countries were not very well developed on mediation yet in Europe at that time. And so, many different rules have been created. And I think what would have helped if you have a mediation guideline like that define at least what you see what mediation is and what it isn't, because it was so broad. And also mediator wasn't defined. Many different processes can fall under it. And that's why in some countries, like I think it's Estonia, they also had a quite extensive conciliation legislation. And they just added into the legislation with under conciliation, we also think that also encompasses mediation. So it's a very different process. Here in the Netherlands, we couldn't agree at all on mediation legislation. So we still don't have mediation legislation here, just to give an example. So how we implemented the mediation directive is that we just set for cross-border cases in the Netherlands, the mediation directive counts. So for cross-border mediation without any, legal background or having it embedded in legislation, really far-going things like the right to refuse testimony and those kinds of things are being regulated by just this one small sentence. But here in the Netherlands, for the national mediations, we don't have legislation at all.
Yes, it looks like Netherlands might need a mediator to help, the parties get a solution for this dispute.
Yes.
And maybe a mediator from Belgium could help.
Yes, that would be. So if somebody hears this, and please make yourself known to the Dutch legal ministry.
For mediators working transnationally, what cultural markers or contrasts should they be most sensitive to, such as approaches to time, communication, or authority?
I think all three of them are super important because they are some of the markers that define cultural bulbs or cultural understanding. Probably it starts with communication, because if you want to discuss time or authority, or you need a way of communicating, and there are very different ways of communicating. And I don't just mean what we do on national mediations, but I more mean what a general communication style is. So are you more outgoing? Is it okay to interrupt? Are you, warm, emotional, or are you more cool, fact-based and very tap? We do it like that, or is it more that it is very important to be very respectful and be more silent? So those kind of clusters where you can be in. So it's really important as a mediator to think about beforehand, before you enter into a mediation, what kind of communication styles can I probably expect? Always check your assumptions, of course. And then if you have a co-mediator with a different cultural background, of course, that counts also for it. And after that, then comes time and the authority. Probably because it is mediation and it is a process where you are more or less the manager of the process. I think something like how much authority and uncertainty avoidance is involved, because that will define the expectations and how people feel comfortable or not comfortable with your mediation style, to a big extent at least. And then time, I think that is something that needs to be discussed in every mediation, because what is your time horizon? How fast would you like to go? Or do you say, I will take all the time that is necessary in order to find a solution? That's also in national mediations an issue. However, here you get the cultural layer. So you would mediate in German-speaking countries. Generally, parties see it more a little bit like a social process. And so the process can take as much time as it needs in order to get the best possible outcome for everybody. Whereas if we go back to Anglo-Saxon countries, it's more like time is money, it needs to be fast. And so it's one of the things that you need to mediate first as part of the expectations of the parties.
Would you advocate for developing a more precise vocabulary to distinguish between the varied practices currently grouped under mediation?
I think yes, but vocabulary words need to be interpreted again. So when I speak with colleagues and we use the word mediation, we can have wildly different ideas of what the process entails. So I would actually more advocate that you are going to be clear on what the parties can expect from the mediation. So for my style as mediator, this is what you can expect. It is difficult to explain that as a mediator. However, I would give it a try because there lies the gold. If people understand what you are doing, they feel more comfortable. With a Dutch colleague, we just produced some videos where we are demonstrating how is in the same case with the same parties, if a mediator is more directive on the process or very facilitative, what does it look like? How would the mediator do that and how can parties react to that? And same with the substance. And I think we need more of those kind of things to just to clarify what you can expect.
Well, if we explore the differences across mediation specializations, you don't mediate the same way a family matter than an administrative matter. In your comparative research, how have you seen mediation practices differ across fields like commercial mediation, family mediation, juvenile penal mediation, administrative mediation, or even medical mediation?
Yeah, there are very different fields, and I think for mediators it's good to specialize. So I don't believe in I'm a general mediator and I can mediate all cases and under all circumstances. Because if you have juvenile mediation, juvenile penal mediation, or family mediation, I think you need a different type and style of mediator than if you have a commercial case, for example. And emotions play a different role. Of course, the emotions are there in each and every case. However, the expectation of how much a mediator will deal with that or how deep the emotions run are generally different. Now, the variegated landscape of mediation did not look at different fields. So it was just civil and commercial law, and in particularly more the business and workplace related cases. So I cannot tell anything about how that is from research, but from my experiences of at the start being a mediator, doing different cases, I've seen that you need a different approach in each one, and so you need to be a specialist in types of cases. If you have a family company, you need to approach it very different than if there are two commercial people sitting together where a deal didn't work. So they are very different.
What are the particular ethical or procedural challenges that you feel are unique to some of these specializations? For example, how does juvenile penal mediation or victim offender mediation reshape the mediator's role compared to commercial mediation?
Yeah, what for me is a big learning from the colleagues who do juvenile penal mediation or victim offender mediation is that it is not so much about finding resolution and on a practical level, but that it is really important to be listened to be understood, to make some shifts and mindsets. Whereas in commercial mediation, quite often we have the tendency to start focusing sometimes too soon on the substance, and there is always, like you said at the beginning, the layer where the relationship, etc., is there. I think there is one of the really big things where we can go into mediation, learn from each other. Not saying like this is the best way how to do these cases, but like this is how I do it, and this is where it worked, and this is where it didn't work. And then you can make your own toolbox with your own mediation style, which fits to you with your personality and the type of parties that and the type of cases that you're going to attract.
When looking across these sectors, do you see more shared practices than differences, or should we need to tailor mediation, education, and framework more carefully to each field?
I think it makes sense to first have a more or less joint basic type of learning mediation. So where you can do general cases and that we could agree on at least here are the borders. This is mediation and this is the gray zones and that is not mediation anymore. And then teach mediators to develop their own style. And that is what I am missing a lot in mediation education, that it's like, this is what you need to do. This is how it's being done. You're allowed to do this. You're not allowed to do that. And, the practice is so unpredictable. And the beauty of mediation is that it is flexible and adaptable. So let's use that. Let's help each mediator to develop a style where they can be the best mediator version of themselves they can be. And then it makes sense to have specializations, to look into a particular type of cases. So what generally works well in these type of cases. So that's how, in my perfect world, it would be.
What innovations or good practices in one sector, say administrative or medical mediation, have you observed that you think should be borrowed and adapted by mediators in other fields?
Well, what I like a lot about certain types of employment mediations is that they follow often a pretty similar stream. So the employee is either sick or has issues or wants to reintegrate again, or it is an exit mediation, and they have their pretty well-known dynamics. And what is quite often done is saying, okay, what things do you already agree on? Do you have the same objective or not? And very often one party says, no, we want to part. And the other party says, no, I want to make up. And a very good practice that came out of that is not saying, okay, you have to agree beforehand what is the objective. So, okay, let's just explore both routes and maybe we can find a third way. So I like that a lot. Another innovation or good practice that is actually proceeding different sectors is the Universal Disclosure Protocol for Mediators, the UDPM. I love it a lot. Don't know whether you know it, but if not, there's a website, and I would definitely advise to have a look at that. Instead, there were a couple of colleagues, Anna Gonzalez being one of them, since she's a very big proponent of this.
Yes, we had to sign, underwrite this proposal, right?
That's only the first step. Now, where I personally think the beauty is of this is how you apply it in practice. So it's not like the green pledge where you say, yeah, I will think about the way you use glass cups, or, can we just put the heating a little bit down during the mediation. No, here it has a very valuable practical component. So instead of discussing what is good mediation? What is not good mediation? Am I allowed to do this practice or not that practice? What to expect? Why don't you make a disclosure protocol as a mediator and just write, if you work with me, this is how I go about mediation. This is what you can expect. Because once again, we hit words like, okay, I am totally neutral and independent. Well, some mediators say that means I never ever had any contact with any of the parties or the lawyers. Other mediators say, well, I did not do a mediation with these parties at the table, but if I had prior contacts, as long as I disclose it, it is fine. Or I am a repeat mediator with these lawyers. So if you say, yeah, I'm neutral and independent, describe what you mean by that. And so that's what I love a lot about this. And first I thought, a lot of this is regulated in my mediation agreement and in the rules, etc. But there are still these fine things where you need to explain. Another thing that came while writing my own UDPM was that you say, okay, GDPR rules, this is how I deal with it. I need to, have a file and have your names on file, etc. But then I also have my bookkeeper. The bookkeeper sees the invoices I sent. the government, the tax authorities also see that. See, there was a mediation on this party. So I thought, okay, I need to disclose that because, of course, I'm not talking to anybody about it. I'm not disclosing anything about the substance. However, saying, nobody will ever know that you did a mediation, that's not true. Because I need to send the invoices to the tax authorities. So those kind of little details, I love a lot about the UDPM because you can write them and parties know, okay, so my bookkeeper signed a non-disclosure agreement, for example, and those things. So I think there lies a great innovation. And the other innovation, what we already touched on earlier, I am a big fan of hybrid proceedings. In order to break through the expectations of the parties who want to have the certainty that there is an outcome or the help to sell it to their constituency, while also at the same time using the best practices in mediation. And so if you either work with two professionals, so you can have one more evaluative type of mediator, or maybe even an arbitrator or informal arbitrator, and you have mediator, you start mediating first, do all of the things you can do, but then if something substantive comes up where they really cannot agree, maybe bring in this other person. And I have very good experiences with doing that, because you can really help the parties to find a solution, even for very, very difficult cases where it's not possible for them to do it just on their own, even with the help of a mediator.
Well, I have to trust your experience.
I would say try it out.
Looking ahead, where do you see the biggest opportunities for improving or harmonizing mediation practices internationally?
Yeah, I come back to the disclosure protocol. So
Yes.
For me, the most important measuring where is it still mediation and where is it not mediation is the party autonomy. And that can be that the parties from their autonomy ask, I would like you to come up with a proposal. Okay, for me, that's still party autonomy, but I cannot do it on my own. So, okay, let me tell you this. So I think a very big step forward within mediation would be if we can all agree on at least one standard, like, for example, party autonomy, or this is mediation or that is not mediation anymore, but not by defining it in a legal way, but more from broad ethical ways. And then stop legalizing mediation in the sense that you really want to regulate everything and want to impose your way of mediating to others, because there's not one style or one approach that will work across the entire world. So let's try to find things that can stimulate mediation, and that can stimulate, for example, things like the party autonomy. So this disclosure protocol helps educating the parties about what to expect from a mediator, and what does it look like if you have a very directive mediator, or if you have a very evaluative or very facilitative mediator, so that they can make an informed choice about what type of mediation they would like to have. And then also be a little bit more adventurous as mediators. So like experiment a little bit more. I think we are a little bit too strict towards each other. Sometimes also here in the Netherlands, when I discuss with colleagues on how I sometimes go about certain mediations, because, there were special circumstances and we couldn't find agreement in the normal way, that you use some tools or techniques that are, maybe not inside the regular spectrum. But hey, if it helps, why not? And if somebody else thinks, no, I want to be super strict and I want to, adhere to all of the rules, fantastic, why not? So as long as the parties know what they are buying into with you, that is good. So stop measuring each other and see it more with a mediative mindset, in a way, like, okay, what can I learn from this? What is the main takeaway? Is that something that I could apply, or is it something where I say, no, that wouldn't fit with me and my style? So know your style and develop it by learning from others.
I am intrigued. Why? What kind of unusual techniques have you been using?
Well, for example, if you are at the end, parties can't find an agreement, and then you brainstorm with them and you say, "Okay, would you like me to do a mediator proposal? What do you think that would help? Or would you like me to play devil's advocate? Or do you give me permission to play the devil's advocate now here?" And then suddenly you have the permission, and you can do everything in a mediation. Sometimes you, with doing mediator proposals, do things like, or maybe mainly actually, if it's just about the money, I mean, proposal can be about anything, but if it's about the money and there's still a gap, you are testing the waters a little bit, asking them, okay, so what would you say if I would come up with a proposal between X and Y? And then maybe at that end, maybe we don't know. And you ask exactly all of them with the others, and you go in the middle. The other thing, which are, let's say, not in the, as in most countries, regularly spectrum of what you do in mediation, is I sometimes just have meetings with the lawyers. I recently had a case with a family company where there were so much emotions that it was not possible to do a productive mediation. It was not possible to have a session. So we said, okay, let's sit together with the lawyers. Let's try to figure out what probably the main interests of each of the parties are and what interest they would have in collaborating more. Because one of the parties drew out of the mediation, said, I don't want to do this anymore. But any alternative would be a disaster for the family, for the company, for everything. And then with all the lawyers around the table, we came up with the idea, okay, it is a bit counterintuitive, but let's not start working on the relationship first. Let's see whether they can find some solutions on the substantive aspects first. Because if we look at it just neutrally, without emotions, etc., there are probably some overlaps in what they would like to do. And then you sit together, two persons from the family who don't have the best relationship among themselves, but who were the ones who had least emotions that stood in the way, so that were able to look at it a little bit more from. So those are counterintuitive things to do as a mediator. Usually you think, okay, those who have a possibility to discuss together, or who really have the biggest issues that need to be solved between them, we said, okay, we're not going to do that. We're first going to have a look at whether at some points you can find a solution. And after that, and you are all a little bit more relaxed, like, okay, actually, we are not totally enemies. Maybe we can start working on a relationship. So those kind of things, those are just a couple of examples.
We seem to be living in a more and more polarized world.
Oh, yeah.
Do you see that entering the mediation process and how people in mediation behave towards each other, not just locally, but also on an international level when you do national mediations?
Actually, I see two developments. On one hand, there is much more polarization, and so people get more triggered easily. They get more angry, and they very, very quickly go, down the glasswall scales towards total escalation. But I also see another development, which I find very encouraging, that people actually think, well, let's not do that. We have to find a solution ourselves. Let's sit around the table and talk. And I very much hope that we will all go that direction, because no matter how big the problems are and whether they are more from a philosophical or a normative level or a substantive level, it always makes sense to sit around the table and speak and see each other as a human being, instead of just an idea and fight with each other. So yes, on one hand, of course, in particularly if you look at the world scale and between countries, and it's very sad and discouraging what is happening. At the same time, on a micro level, I do see encouraging developments.
How realistic or desirable is it to work towards shared international standard, or is local flexibility the real strength of mediation?
I meanwhile think that we really need to be very careful with regulating mediation too much. And we already have issues within countries to find standards. What is mediation? What's good mediation practice and what not? So let alone on a world scale, if you make ethical rules or codes of conduct, they should be very, very short and, only reflecting the things that are really 100% accepted by the entire world. Otherwise, you can't have a world standard. And so I would be more a proponent of having codes of conduct or pledges maybe that are more facilitating the use of mediation type of processes. So let's always talk before. And then combine that with putting a lot of emphasis on the party autonomy and being clear about what we expect. So let the parties decide for themselves whether I want this type of mediator or this type of mediation or not. I think that would be more helpful than going through a multi-year effort of convincing somebody that your way of mediating is better than mine.
That's fair. If you were to add a new chapter to the book today, what topic or jurisdiction would you most want to cover?
I would definitely go more in depth with the styles and be more clear about what does it mean to have this style? What can you expect? What do you see the mediator do? And what are the effects of that? So that would be a chapter. Also a chapter on mediation advocacy and how that is dealt with in the different countries would be very useful. However, the most useful thing would be to have an update of the book because it was already in 2014. However, I don't have the time. So if anybody is listening to this and saying, "Oh yeah, I'm intrigued. I would, love to make an update," do get in touch if you are interested in doing that.
So we're getting towards the end of this conversation, and you've been very gracious. Thank you. I wanted to explore if there are things that I should have explored more, if there are things that you want to talk about. And maybe, look at this from the perspective of mediation. If there's anything that you believe we should be talking about, but we are not.
I think we covered the most important things, and that you gave me the opportunity to express, let's say, my crusade here. Which is on one hand, okay, let's be flexible and have hybrids and experiment with each other, and then mediate the process and be clear on what you can expect for the party. So so thank you very much for giving me the opportunity to speak about the things that I very much care about, and for your thoughtful questions, which I very much enjoyed it. Thank you.
Thank you, Manon. It's been a real pleasure.